viewers, welcome to the Personal Injury Law Show. This is a show that talks about everything relevant in the law of personal injuries today, and it's relevant to you, the viewer. My name's Tony Carbone. I'm a lawyer of nearly 30 years experience. With me tonight, I've got a partner of a law firm, Nunzio Tartaglia.
Tony, viewers, welcome.
And also Alvin, a partner in the law firm. Good evening, Alvin.
Good evening, Tony. Good evening, viewers.
Tonight, viewers, have got a riveting show about occupier's liability. It's very relevant because this is what you've got to do to prevent getting sued. So please stay tuned for that.
Tony, before we kick off, what's in the news?
Well, Nunzio, viewers, we've got a lot of stories, but we're going to do the ones that are very relevant and things that you'll find interesting. The first one's a breast cancer patient wins a payout for a misdiagnosis by a pathology department. What's the story about, Nunz?
Yeah, it was Rosemary Morley, approximately 8 years ago, had a lump removed and had to be tested for cancer, and I think it was Dr. Egan at the time in the Melbourne pathology unfortunately failed to diagnose that she had cancer, and since then has had two double mastectomies, gone through a lot of grief, and look, they've reached an out-of-court settlement from what I understand from the article, and it just shows that you've got to be very careful in matters of this nature. And
Alvin, what's the relevance of this lady's one of her best friends dying from breast cancer as well?
It goes towards her claim for pain and suffering, also her psychological condition. As it is, she's suffering from a major condition. She's going through pain and suffering. All of a sudden, her friend has also been diagnosed with breast cancer. Just increases her
anxiety levels.
Anxiety levels, yeah.
Isn't it a case that her morbidity all of a sudden is escalated, Nunz? Because her best friend dies from breast cancer. She's got breast cancer.
Yeah, look, I think it just, I suppose, accelerates the whole situation. It doesn't make it any easier at all.
No.
So, but look, it's just, it just highlights the fact that these things do happen, and you can be compensated for a misdiagnosis, and the law provides for that, Tony. So,
and she does say too that she's really concerned about it coming back.
Yeah, look, it's always going to have the risk, and it's going to play on your mind, and that's something that you shouldn't live with. And
all right,
look, that's why I think a settlement would have been reached.
Let's keep moving. There's a ban on teen cosmetic surgery proposed. Alvin, what's this all about?
Obviously, there's been a lot of concerns about cosmetic surgeons who are not properly trained or adequately qualified to perform these procedures. Unfortunately, teenagers tend to go through these procedures, including liposuction or lip augmentation, and unfortunately, they have severe consequences. Hence the reason why there's a push for uniform guidelines so that procedures are undertaken in a proper and safe manner.
Nunz, isn't there a bigger issue that under 18s, they're acting impulsively too? I mean, you've got to...
Oh, look, they're not probably at a mature level to make those informed decisions. That's why they want to introduce, bans like that in Queensland where you can't have cosmetic surgery under 18 years of age. But it staggers me that in Victoria, you have to consent for, a tattoo or a piercing, but not cosmetic surgery. And I would have thought that's probably a little bit more serious in nature.
I guess the flip side to that is if they don't permit them to do it here, they'll just go overseas to Asia, and that puts them even at greater risk.
Look, I appreciate that, but look, the fact is they've got parents, and if they've got parents who reside in the country, that we've got to try to get their involvement in there, because they're under 18, unfortunately, they don't know, I suppose they're not mature enough to know and make informed decisions.
And Nunz, do you honestly believe that parents know everything that their children are doing?
Probably not, Tony.
Yeah. Look, this is a very hot topic, and if you recall the last time when we had the plastic surgeon on the show, maybe we can deal with that in due course.
Yeah.
Just one quick issue regarding that is obviously, as Nunzio was saying, that they have to be mature enough. The laws in Victoria at the moment is if someone's under the age of 18, as long as the cosmetic surgeon forms the view that he or she, the patient, is mature enough, they can perform the surgery, which is a bit farcical in that sense. How can you come to the conclusion that they're mature enough when they aren't really?
I reckon it's a bit risky on the part of the surgeon because you could get sued in due course. If something goes wrong, the parents could turn around and say, hey, hold it, you should have come to us, or you should have taken the appropriate avenues to make sure.
If I was a surgeon, I'd be very reluctant to perform surgery on someone under 18 years of age.
I mean, the law doesn't permit the police to interview an under 18 without an adult present. So.
I think there's got to be more regulation, so more to come, I think, with that one, Tony.
All right, let's have a look at this juicy story of a soccer fan who sues the police for being repeatedly punched and after he was ejected from a soccer match. What's this all about, Nunz?
It's staggering. Now he's a plaintiff because he's issued court proceedings, but was ejected from a Melbourne Victory game. I think it was in sometime in 2011. Really unexpected is they basically removed everyone out of the row and punched, abused him, and a lot by what the article says. Was charged, but then obviously the charges were dismissed, and now he's issued proceedings against the state of Victoria, I think it was,
and the individual police officer.
So it's just staggering that it just seems unexpected and unprovoked. That's from what my reading of it is.
Well, the funny thing about it is that the police, it's not funny, but what I'm saying, the strange thing about this one is the police said that it's a malicious prosecution and because he bit a police officer, and the thing is that added to his aggravation and pain and suffering.
Absolutely right. At the end of the day, it went to court. The judge found that there was malicious prosecution by the police. In terms of the Mr. Curran, who was obviously assaulted by the police, he is now brought on proceedings. He's claiming exemplary damages, which is punitive damages for the side claim, because his family was at the game. Also, the incident was broadcast live on TV.
Tony, do you think he'll get up on that?
Exemplary damages is punishment.
Yeah, do you think he'll get up on that?
I think he will.
Yeah.
And chances are, this is the thing that people out there don't understand. And also when people get I was at the footy recently and there was fights left, right and centre. People videotape these fights. And I mean, you can't hide behind a video. If it shows you throwing punches and carrying on, I mean, it's pretty damning evidence, don't you think?
Yeah, look, of course, video is always going to be the most compelling type of evidence.
And I'd imagine in this case here, there would be some video of a spectator.
Of course.
Taking,
and look, just quickly, Tony, I suppose on the law, usually for a matter of this sort, the gateway, the threshold is you need a 5% impairment or a 10% psychological.
Not when there's an assault.
Yeah, but when because it's an assault, I said it's regarded as an intentional tort, and you can just issue proceedings, no impairment required. It's just a matter of really assessing his damages if you can prove negligence.
That's a very good point. And Alvin, just on that point, when you do sue, you're also suing for pain and suffering, loss of enjoyment of life, and loss of income and medical expenses. Is that correct? And in some instances where you need other people's help because you can't carry your day-to-day chores, you can claim that as a commercial cost as well.
Of course.
Yep. All right, what about this person that fell over in Rockhampton supermarket on cauliflower, $230,000 on a cauliflower leaf?
Yeah, look, it's not uncommon that obviously cases against Woolworths have been issued, but said they're a nationwide chain with so many stores, and look, this is just purely a slipping case, Tony. It'll come down to proving whether the Woolworths system of cleaning inspection is adequate enough, and if it's not, then that type of damages is not unreasonable.
What about this guy who lost his ear, right? And Mike Tyson was nowhere near him. He was attacked by a dog. Dog jumped up and bit his ear off.
Yeah, Tony, look, we've spoken about dogs for many weeks in the show, and this gentleman lost his ear, and the fine that was awarded against the owner of the dog was $4,400 and some legal fees of $2,200. Those laws don't work for me, but we'll talk about another episode.
Exactly. Viewers, we've got to go to a sponsored break, so please stay tuned, because after the break we're going to be talking about your responsibilities as occupiers of homes, restaurants and the like. Viewers, tonight we're talking about occupiers' liability. That is, what are the obligations of the owners of residences, restaurants, supermarkets, and also what rights do you have as an invitee or a trespasser? So, Nunzio, tell me, what does occupiers' liability encompass?
Well, look, to, I suppose, break it down for the viewers, Tony, basically there's a duty on occupiers, and as you say, whether you're a homeowner, whether you're a shop owner, whether you're a school or anything to that effect, where you occupy some sort of premises, you have a duty basically to make sure that there's a safe premises, and if there is anything of risk, you need to, I suppose, look at that risk and do things to make sure it doesn't pose any danger to a plaintiff or a person. So it's making sure that there's no risk out there so no one gets injured.
And the law does say, Alvin, that the common law says that there is a duty of care.
Yes, it is.
And that's been codified, which under the Wrongs Act, sections
14B.
B and 14B subsection 2. What does that mean?
What it does means is that, as Nunzio has said, an occupier has a duty, reasonable duty to make sure that people are not injured by the state of the premises, things done or omitted to be done in relation to the premises. What it means is that you've got to provide a safe premises. However, also at the same time, it's not an absolute duty on the occupier of the premises that everything has to be safe. They have to take reasonable action based on the circumstances of the matter for the safety of patrons or individuals attending the premises.
Tony, what does reasonable action mean?
Reasonable action means you've got to, what is reasonably foreseeable as the occupier that people could be injured. For example, you're walking into the premises, there's a cracked tile. Any reasonable person will know that that cracked tile could lead to an injury, correct?
Yep.
It's as simple as that. Let's go to the classes of people that could be on premises. You could be a trespasser, they're still covered.
Yep.
You could be a licensee, right? You could be an invitee, you're invited, you go knock on a door, you're visiting someone. You could be an entrant as of right, that is you go onto a public park and things like that. And you could also be a contractual entrant. You go to a sporting event like the car races and horse racing and things
Football,
like that.
anything, yeah.
And in fact, Alvin, if you go to an event under where you buy a ticket and it's pursuant to a contract, your rights are a bit higher, aren't they? There's a higher onus on the occupier to ensure that the place is safe.
Absolutely.
Because you can rely on contractual.
There's a contractual right as well.
Contractual obligation.
I suppose a lesson here for all those different classes of persons that there could be a case anywhere with respect to an occupier's liability action, and so therefore you need to have insurance because it can happen any time, any place, and one innocuous accident can cause hundreds of thousands worth of damage. So you need to get insurance for these instances. So that's a big lesson for viewers out there.
Even at home, you've got to have home and contents insurance because you've got someone coming along to your premises, someone gets injured due to the state of the premises, they can sue you. So it's very important that you have home and contents insurance as well.
Well, just on that point, Alvin, the things that people should be looking at are things like uneven, unsafe surfaces, cracks, gaps and potholes, slippery surfaces, wet floors, flooring, missing or loose handrails or stairs, debris on the walking paths, e.g. boxes in the aisles, inadequate lighting, insufficient signage. Signage is good. Unsafe, overused or deteriorating furniture, restaurants, pubs and clubs. So there's a lot of things you've got to look out for. When you establish occupier's liability, what are the key elements to it, Alvin?
Key elements are that is there a risk, a foreseeable risk? If it is, then what action would a reasonable person take to ensure that someone's not injured by the state of the premises?
Can I stop you there for a minute? The law talks about reasonable foreseeability. Nunz, does that mean, being objective, could you foresee harm coming upon a person based on the fact that you failed to repair something or that you're doing something that could lead to harm?
Yeah.
Is that correct?
Yeah, basically, and look, the law says it can't be far-fetched and fanciful. So as long as I said, again, we keep saying a reasonable person can identify that a particular, omission or state of the premise can cause damage, then, arguably there's an action against the occupier. Look, it's a difficult one to explain in one sentence for viewers, but it's making sure that effectively there's no, I suppose, poses of danger or risk.
Well, in most instances, it's fair to say that there is a duty of care, okay? Yeah. So invariably what an injured person will have to show is that there's been a breach of duty by the occupier. Is that correct?
Yeah, generally that's the big argument in these cases. Most occupiers do have a duty. I think that's fairly, I think that's fairly set in concrete. But it's have you breached that duty, and that's always the argument when it comes down to these cases.
And Alvin, the reason why we're having this discussion is because people often have dinner parties and things like that, and it's really to look after people like yourselves, where you've got people over for dinner parties, barbecues, social gatherings, and there's a lot of things that go wrong, isn't there?
Oh yes. If you're inviting people over, make sure, first of all, that the premises is free of obstruction, the surface is all safe. I think we're asking for way too much, but unfortunately that's what the law is. If things are not safe or proper and someone gets injured, you're liable to be sued.
And a good example, sorry.
So I'll give you examples. I said we actually had a function at home recently, and I saw my mum cutting all the edges of the branches, which are near the walkway of our premises. And I asked her, why are you doing that for? And she said, well, to make sure there's no pointy ends so then no one gets injured, because there's going to be a bit of dancing and there's going to be a bit of drinking, and that could pose a risk. And, look, it's something innocuous like that can cause some severe damage. Someone puts it in their eye and they're blind.
Well, my neighbour years ago had a barbecue, a gas one, and hadn't used the, where the gas goes, the cylinder, for many, many years. When his friend went to light it up, it actually exploded.
Oh, geez.
So he was very lucky the person didn't get injured, because that would have been a very, very big claim.
Of course.
So what you basically got to do is scour the place, check it out for potholes, cracked tiles, wet floors. I mean, you've essentially got to do what they do in nightclubs and that. You've got to make sure that there's no liquid on the ground so people can't slip over.
Of course.
And plus, you've got to watch out for kids. In a lot of instances where you've got people over, Alvin, they bring over a lot of children, young ones. They're running around and getting in people's way. I mean, that's a circumstance where you could sue the occupier for failing to keep the kids under control. Correct?
It could go that far as well.
All right. Who's going to give me the facts of Indigo Mist, Proprietary Limited, and Palmer? I think we'll go to some case law.
Look, this is a case, Tony, in which the plaintiff is suing a hotel in Sydney, and also it's the architect who did some refurbishments or architectural designs of the premises. This is an action in New South Wales. The plaintiff was successful for about 115,000, I think it was, and it was basically proven that both the hotel and the architectural firm were negligent. What happened to her though? She slipped on glass floor. It was
a staircase.
Yeah, staircase. It was in between. I think it was 2 or 3 levels of this building, and you could take drinks up and down the stairs. It was slippery, and she
Stop a
slipped
minute.
over.
You've raised 2 very important points, aren't they, Alvin?
Absolutely.
1, glass floor, and 2, the drinks. And the significance of that, we'll come back to it because we've got to get our sponsors break. So stay tuned. Viewers, welcome back to the show. Before the break, I was telling you that there were 2 key pieces of evidence that were crucial in this particular case. 1, the floor was made of glass. And 2, people were going up and down the stairs, that is from floor 2 to floor 3, carrying drinks. So when you get spillages on glass, what happens, Nunzio?
Well, obviously very slippery, Tony, and this was proven. There was
It's a nice skating rink.
Yeah, of course, and there was expert evidence in this case to show that when the floor had some liquid substance on it or slippery substance, that it was wet and dangerous. So there's effectively in this case there's 2 aspects of it. One was it was basically negligent of the architect to recommend that you implement a glass floor, and 2, that because of, I suppose, the setup at the premises going up and down with drinks.
Well, management should have prevented that.
That's what they should prevent. So there's 2 issues.
Alvin, when the architect got in a witness box and was asked a critical question about why the floor was made of glass, what was his answer?
That was the recommendation, and that stick with the recommendation that it be glass staircase.
So he wouldn't have done any different.
In so many words, Tony, basically he said that if he knew that it was slippery when wet, the architect still would have recommended the glass floor, which is staggering, isn't it?
Who does that?
Look, this architect simply, the way I read the case was that I'm an architect, that's what I do. I'm giving you the most fancy premises going around. I don't care about the safety. I don't care about I suppose the practicality of it. I'm just giving you something that looks.
Well, the
cool.
occupier should have prevented people carrying liquids up and down the stairs.
Well, that's why. Look, it ended up being like a 50-50 split in terms of the 115 grand that was awarded to the plaintiff. But both defendants had a lot to answer for in this case because. In relation to the hotel, a lot of commentary was on the system of cleaning inspection. They basically had not an adequate system to make sure that a slippery substance would have been picked up.
Do you know what this reminds me of, this case? Do you remember the case you did involving the reception centre where, because there were so many guests invited, viewers, they put the tables on the dance floor, and the judge in that particular case said, if the plaintiff can prove that there was tables on the dance floor, there is no way the occupier could prevent liquid hitting the ground. Once that was proven, she found a breach.
Exactly.
Correct?
And that's why, as you mentioned before, Tony, these nightclub cases are quite, I suppose, there's a lot of them around because, with a lot of people dancing, it's dark, it's, a lot of people drunk, there's always a lot of liquid on the floor and it creates a nice skating rink at times.
And Alvin, you'll find that in a lot of instances, Nunzio raised the issue of nightclubs, they do go on the dance floor with drinks.
They do.
And where are they going to go? On the floor.
Absolutely. Goes to the principle, the basic principles of occupier's liability. The occupier has to be very mindful of the nature of the premises. In this instance, what I don't understand is that the architect saying, well, I wouldn't have changed my mind. They would have known at the very first place, this is a nightclub, this is a hotel where there'd be patrons taking drinks up and down the stairs. It's going to be slippery, people will fall. However, they chose not to take that into account when doing the refurbishment of the premises.
In fact, what they should have done is put signs up and also stop people from taking glasses up and down the stairs.
Yeah, and look...
and it still would have made it risky.
This was on appeal, and basically the judge on appeal said that it would have been a cheap alternative to basically ensure that this didn't happen.
From nightclubs, restaurants, pubs, bars,
Supermarkets.
Supermarkets is big. Yeah.
Look, supermarkets are big because, as I said, it's it's a big area, and look, it is hard for an occupier to have cleaners going around every 5-10 minutes. It is difficult, hence why we do get a lot of inquiries in that regard.
Do you remember the one you did where they had the bread, all the crumbs were landing on the ground?
Yeah.
And when you stepped on it, it got really slippery. In fact, when we went to take some photos, you fell over too, didn't you?
I was very close to it, Tony.
Yeah. All right. Can you give us the facts of Novakovic and Stikovic, Alvin?
This is a case where Ms. Novakovic used to go to her relatives, Mr. and Mrs. Stekovic. Mr. Stekovic was a brother and Mrs. Stekovic was a sister-in-law. He used to go there every fortnight. On this instance, she enters the premises with 3 other friends. There's a dog inside the house. She panics. The dog was just sitting on the ground, just gets up and just makes its way towards the plaintiff. The plaintiff panics for no obvious reason, decides to run out of the house, closes the door and trips and falls on the tile patio. She brings in a case against her in-laws, initially saying that the tiles were slippery. However, they then changed the position to the fact that it was a dangerous dog. The owners should have known that it was a dangerous dog, shouldn't have permitted the dog to stay in the house, and as a result, she got injured. They should have also known that she had a genuine fear for dogs. It was a dangerous dog and they should have not allowed the dog inside the house.
Well, the issue about the dog was this. She saw the dog, she panicked, she started running.
That's right.
And then she slipped on what she said was slippery tiles.
Yeah.
Yeah. She lost.
Yeah, look, this went to appeal, and what was interesting is that the plaintiff's lawyers obviously changed tack halfway through because their first case, the way they tried to put it, was that it was a slippery surface, so really the dog had nothing to do with it, which is probably the easier way to win the case. But then
that wasn't lost on the judge, was it?
No, because they did some slip tests and they found out from both plaintiff and defendant side that when wet it wasn't slippery. So that side of the case was gone. They could not win on that part. So then they went down the dog aspect of it.
If they had gone with the dog first, run away from the dog, and then slipped, I reckon the case would have been okay.
Look, it would have looked better, Tony. Whether it got up is another question, but it would have looked better.
Would have been a better case.
Yeah. Look, problem with this one that I think the plaintiff was using facts to try and suit their case, but it didn't work. For instance, she said that this dog was dangerous and that it had bitten other people before. It was a hunting dog, but all this stuff happened after the event.
If the dog had bitten her, the case would have been good.
Yeah, that's right.
Anyway, it's a very poor presented case.
Yeah, and look, it's just a lesson to homeowners again that, look, something like this could happen and someone might sue you because of it. Look, they might not have a viable case, but why would you want to be paying out thousands in legal fees and potential settlement when you just could have insurance, pass it on, and the insurance company deals
Exactly.
with it. So.
Let's go to a case that did win. Orchard and Balcliffe Proprietary Limited. Give me the facts briefly, Nunz.
Oh, this is a case basically in which a patron of a hotel was severely bashed, had brain damage, 1.4 million compensation. But the interesting part about it was that he was bashed across the road from the hotel by a glassy inside so he worked for the hotel and he wasn't part of the security company. And eventually it was found that the hotel was liable for 70% of the damages and the security company 30%.
And the critical part of this case was the fact that the fellow that did the glassing was a glassy and worked for the occupier. Is that correct?
Yes, that's the critical element. However, adding on to that, in this instance, the court did not find that what the glassy did in that instance was in furtherance of their employment. However, it was more so because the hotel had a liquor license. The liquor license required that the vicinity of the area near the vicinity of the hotel, patrons should be walking out in a quiet and orderly manner, not to make any noise. And in this instance, there was a scuffle, there was an altercation between the plaintiff and another individual, and the security company employed or engaged by the employer should have ensured that subsided. However, they didn't do anything, and this employee comes out and assaults the plaintiff.
Anything else you'd like to add before we go?
Yeah, look, just to the viewers, look, it's really important, you know, if you've had injuries of this nature, you know, whether it's supermarkets, hotels, nightclubs, at a home, do seek the advice of a lawyer, because as I said, you do have rights, and you know, we're happy to help.
Nunz, Alvin, thank you for coming on board. Viewers, don't forget to go to Twitter and Facebook. Tonight's one of those episodes where you can Twitter all you like, because it picks up everyone. And go to past episodes on YouTube. Please stay tuned for future episodes, and always remember to stay safe.